Good morning, Ilona. Thank you for taking part at this series of interviews focusing on emission reductions rights in the context of jurisdictional REDD+. Before we actually start, can you please introduce yourself?
Sure. I'm Ilona Millar. I am a partner at Gilbert and Tobin, an independent law firm here in Australia, and I lead their practice on climate change and sustainability. I've been working in carbon markets and natural capital solutions for close to 20 years, and looking forward to this discussion.
Thank you very much, Ilona. I would suggest to directly jump to the very first question. As we know, Australia was one of the first countries in regulating carbon rights and has established a sound carbon credits system that other countries in the region are trying to replicate. Can you please tell us more from your country experience, what you consider the key for the success, but also the challenges associated with the forest carbon credits trading?
No, of course. So Australia was one of the first countries that sort of firstly engaged with carbon markets and emissions trading, but also that looked at creating specific rights that enabled a separation of land rights from the trees and vegetation, and then the carbon that was sequestered within trees and within biomass. So it's we have a long history of each of a legal position in respect to the treatment of those rights. There is variation across the different states and territories. So in some cases, they are statutory rights, which are able to be registered on title. In other jurisdictions within our federated system, we have them sort of characterised as profit prondras or rights to take the benefits of. But what has been sort of instrumental in Australia is that by having those separated rights, we've been able to have a very clear and distinct way of defining who has legal title to carbon property, and therefore the ability to undertake emission reduction projects that involve land sector, forest, and other land sector activities. And this has given a solid basis to the ability to then develop methodologies and projects that support emission reductions and emissions avoidance and sequestration across the land sector. So that's, I guess, in terms of, you know, the experience in our country, you know, that we do have those sort of systems in place. One of the issues is that they are different between and across each of the states. That means that we don't have, even though our carbon market legislation is federal legislation under the Carbon Credits Carbon Farming Initiative Act of 2011, you need to sort of do a sort of distinct legal analysis, doing a project in each of the states and territories to look at the carbon property rights in each jurisdiction. So they, like in the same way that our land tenure, our environmental permitting requirements, our water rights are all sort of regulated at a state level, you know, the underlying sort of property rights are dealt with at a state level for carbon projects. So, you know, one of the challenges is that there is that variation, and so you need to be across the detail for whichever state in which a project is being developed. So that's one of the challenges here, is the lack of uniformity. But I think people in the market have, you know, managed to, you know, work through that. The other sort of component that is important here in Australia, and actually I'll pause there and say, you know, when doing a carbon project in Australia, you know, if you are the landholder who's undertaking the project, you don't necessarily need to have secondary rights registered on title. It's only typically where you have a third party who is being conferred, you know, a license to access the land and then rights to develop the project, that you might then see those statutory rights being held in a different name to the name of the landholder. So I think the other point to note, which is important in Australia, is that we do have a national system of native title, which recognises the traditional ownership of land that has, in circumstances where that native title has not otherwise been extinguished. And so we have processes, particularly for land sector projects, where in addition to demonstrating a legal right to the ability to undertake the project, a project proponent will also need to demonstrate that they have all what are called eligible interest holder consents. And that includes the consent of anyone who is a native title claimant or holder, where that claim may affect the ability to undertake the project. So there are additional overlays that apply when you're dealing with land that is not what we call freehold land, and that can also often create challenges for projects, but also there are a number of opportunities to collaborate and partner with traditional owners to undertake projects. And we've seen some really innovative approaches to developing new methodologies that reflect traditional practices in the land sector that have taken off in Australia and indeed also been exported to other countries. For example, the groundbreaking methodologies that we've developed around savanna burning here in Australia.
Very interesting. And that indeed brings us to the second question. Mm-hmm. As we know, you have also experience in supporting developing countries such as PNG, Papua New Guinea, in moving forward and progressing, clarifying the carbon rights. Can you please share your views on what you consider still the major challenges for countries like PNG in Asia Pacific, in terms of what are the main constraints that they're still facing in clarifying carbon rights, and what do you consider the best legal solutions for all the countries in the region in the medium and long term?
Yeah, look, I think the key challenge that we've seen with a number of countries in the Asia Pacific region is the land tenure systems are essentially I'm trying to think of the right word to describe them. You have land tenure systems where the bulk of the land is under community or local ownership, which sort of is fantastic in that it vests the ownership of the land and title and consent rights to the people who live and get the benefit of the land. However, with those tenure systems, it then becomes challenging sometimes for private project developers to undertake projects, because in order to undertake the project, they first need to identify who is the traditional owner group or groups. And in some cases, you have a large number of traditional owner groups that have rights over certain areas of land. And then the process of negotiating with those groups, it's then important to make sure you're negotiating with people who are authorised to speak on behalf of the traditional owners and that are able to give the consents necessary to demonstrate the proof of right to a third party to then be able to undertake a project. So while some, governments have clear processes around recognising local groups and who has the registered authority to speak on behalf of those groups, one of the big challenges we do see is that the processes and appointment of those recognised groups is often contested, and also the agreements that are entered into by private sector parties to develop projects are also often contested by other groups that may have rights in respect of the project area. So that can become quite challenging in terms of both the number of groups that you might need to negotiate with, but also ensuring that the right people are speaking on behalf of the ownership rights for the group. And so that has been a challenge in quite a few countries that I've looked at developing sort of REDD projects, be it through results-based payment programs or through sort of private sector international voluntary carbon market projects. I'm not sure there is a hard and fast one answer on what the best way forward is, because it will be very country specific, having regard to the tenure system in the country, the nature by which traditional owners or communities are recognised under constitutional laws and other legal frameworks. But certainly one approach that was taken in Fiji, for example, was to create a specific legal right to undertake a carbon project, and to also sort of recognise who would be able to have that legal right to achieve the mitigation outcomes. And that provided sort of legislative certainty to enable projects to be developed in that jurisdiction. I think, it is helpful if you have a legislated carbon right, but it really does depend on the jurisdiction in which you're working in as to whether that's appropriate and whether it's something that is in fact able to be effective.
Thank you. Thank you very much. Indeed, we also promote country-based legal solutions when we look at carbon rights. I perfectly agree. You mentioned the private sector. How do you foresee the role of the private sector in the area of carbon rights, even in the context of a jurisdictional REDD+ program?
Look, I think there is a clear role for the private sector to be undertaking certain aspects of project development. The private sector bring a skill set that may not necessarily be present, particularly in terms of some of the technology, the MRV capacity, the ability to use remote sensing and various tools that are more readily available to the private sector and able to be paid for by the private sector. And then also the private sector ability to act as an intermediary to access markets and maximise the financial benefits that are connected to the sale of, be it results or of carbon units. So I think there is a really important role for the private sector in both, conventional project level project development, but also in nested and jurisdictional level programs. It's then a question of how you approach the benefit sharing arrangements that then sit around that in terms of making sure that there is a fair and equitable sharing of benefits between all stakeholders. And so specifically around carbon rights, the approach to carbon rights needs to be determined and, led by government and communities working together to decide whether it's appropriate to create separate, statutory or registrable rights. And that's very much to be determined country by country. Where there are those rights, it does provide greater certainty to the private sector if they are having those rights transferred to them to then underpin the project development that they do. And that legal certainty, de-risks to some extent some of the project costs and long-term investments that are being made in these projects.
Yeah, indeed. Thank you. Just to conclude now, can you please share stories or lessons learned, as you did for PNG and Fiji, showing how certain countries are progressing in the area of carbon rights?
Look, I think certainly here in Australia, we have well-established rights which, you know, have been very helpful to underpin and support the growth of our market. I think we're still waiting to see how markets develop in a number of the countries that have sort of been new to implementing carbon rights, and that's partly as they wait for the rules around Article 6 of the Paris Agreement to really sort of start to be operationalized and implemented. But I expect that there will be benefits for those countries that do have clear carbon property rights to be able to you know, attract investment and support project development in a way that countries that have less certainty about those rights and more of the contested nature of you know, the process of undertaking projects, simply because you know, there is a lot of private capital that is looking to invest in these types of nature-based solutions and land sector projects. But in order for that investment to be made, there needs to be a level of comfort and certainty that the project will be able to continue with the private sector participants that have sort of initiated the project. And if that's at risk, then the investment's at risk, and you won't see as much of the funding, you know, flow to those types of those countries where there isn't that legal certainty. So I appreciate it's early days in a number of countries, but I do think there are benefits in having legal certainty, whether it's sort of confirmation that the existing regime and the title holders who have rights, constitutional rights to the land, clearly have that title and can then, you know, grant or decide not to grant rights to third parties, or otherwise having a right that is clearly identifiable and documented.
Thank you very much, Ilona. Indeed, clarifying carbon rights would help to de-risk, as you were saying, you know, an investment on those countries, avoid any double payments, double accounting, and facilitate transactions, indeed, with the different categories of actors that are involved in reducing emissions from forests. Thank you very much for your insights, and have a very nice rest of the day or the night in Australia.
Great.
Thanks.
My pleasure. Thanks so much.
Bye.
Cheers.